Whether you're grabbing your morning chai, tapping I agree on a new app, or signing a massive business deal, you are constantly interacting with a legal framework that's actually over 150 years old. Today, we're going to deconstruct the absolute cornerstone of all of this, the Indian Contract Act of 1872. We are going to break down piece by piece how a simple everyday promise transforms into a legally binding contract. Right from the get-go, the Act tells us exactly what it's here to do. Its mission? To define and amend. See, this isn't just some random collection of rules. It's the official dictionary and the rulebook for every agreement made in India. It's all about bringing clarity and order to the promises we make to each other. Okay, so that leads us to the big question, right? We make promises all the time. But at what point does the law actually step in and say, hey, you have to follow through on that? What is the secret sauce, that magic ingredient that turns a casual chat into something a court can actually enforce? Well, that's exactly what we're about to find out. Everything, and I mean everything, starts with the absolute basics. You can think of it like a legal handshake. Every single contract out there, no matter how ridiculously complex, is built on these two fundamental actions, a proposal and an acceptance. These are our first building blocks. Now, the Act defines a proposal with some pretty dense legal language. But honestly, it's way simpler than it sounds. It's just an offer. That's it. If I say to you, I'll sell you my pen for 10 rupees, boom. I've just made a proposal. I've shown my willingness to do something, sell the pen, and my whole goal is to get you to say yes. And here we go. This is the other half of that handshake. Acceptance is, quite simply, the yes to the proposal. If you look at my pen and say, deal, I'll take it, you have just signified your assent. You've accepted my offer. And in that very moment, something totally new gets created. And here's the first major transformation. A proposal, once it's been accepted, officially becomes a promise. This is a huge step. My offer to sell the pen, combined with your agreement to buy it, is no longer just a casual suggestion. The law now sees it as a promise. But, a promise by itself isn't quite enough. For the law to really care, something of value has to be exchanged. This brings us to the next absolutely crucial ingredient, which in the legal world is called consideration. The easiest way to think about it? It's the price of the promise. So what consideration really boils down to is the something that each person in the deal gets. In our pen example, my consideration is the 10 rupees you're going to give me. Your consideration is the pen I'm going to give you. It's the what's in it for me part of the deal, and it's essential. Both sides have to get something. All right, let's take stock. We have our building blocks. We have a promise, and we have consideration. Now, when we put these two key elements together, we move up a level. We've officially created an agreement. It really is as simple as this formula. You take a promise, you add consideration for both sides, and what you get is an agreement. Our little deal for the pen, it's not just a promise anymore. It has now leveled up to become a full-fledged agreement. And here you can see the formal definition right from the Act itself, and it confirms exactly what we just said. An agreement is basically a set of mutual promises, where what you're promising is the value, the consideration for what I'm promising, and vice versa. Now this is probably the single most important question in this entire explainer. We've successfully built an agreement. We've got our promise, we've got our consideration. So, are we done? Is this agreement automatically a contract that a court will enforce? Well, the answer might not be what you think. We have finally reached the last, and I'd say most critical step. This is where we draw the line in the sand, separating a casual agreement from a legally powerful contract. So what is that one final element that pushes an agreement over the finish line? And there it is, right there, the two magic words, enforceable by law. This is the game changer. An agreement is just a deal we've made, but a contract is a deal that the legal system is willing to back up. Look, if I agree to sell you the moon for 1 billion rupees, sure, we have an agreement, but it's not a contract because no court is going to enforce it. That enforceability, that is everything. This idea of enforceability is so important that the Act even lays out what happens when it goes wrong. For instance, a void agreement, like our deal to sell the moon, was never a real contract to begin with. A voidable contract is a bit different. That's where maybe one person was forced into it, so they get the option to cancel the deal. And then there's a void contract, which was totally valid at the start, but something happened that made it impossible to finish, like if the pen we were selling got destroyed. So let's just trace our steps one last time. It all kicks off with a simple proposal. That proposal gets an acceptance and it becomes a promise. We add consideration, the price, to build an agreement. And finally, that absolutely critical element of legal enforceability is what transforms that agreement into a powerful, binding contract. So as we wrap this up, just think about your day so far. That coffee you bought this morning, the bus ticket you scanned, the software update you agreed to. Every single one of them involved a proposal, an acceptance, consideration, and was an agreement enforceable by law. So the real question is, how many contracts have you actually been a part of today without even giving it a second thought? The law of contracts, it turns out, is absolutely everywhere.